So today I want to talk about the United States Supreme Court protecting landlords in New York. Now, the U.S. Supreme Court has deemed that part of a law in New York known as CEEFPA that is designed to protect tenants during the pandemic is likely unconstitutional. The law, as it is currently written, allowed tenants to assert that they were under financial hardship due to the pandemic in order to provide protection from eviction. So all that tenants really had to do was sign a form stating, I have had some sort of issue with financial hardship during the course of the pandemic, and it provided instant protection. This injunction by the Supreme Court has deemed that landlords should have the right to challenge those claims, meaning that the courts would be able to means test tenants in favor of landlords in a court of law to determine the severity of the hardship, which means that, of course, the landlords would be able to bring tenants into courts much earlier than anticipated. Now, the oddest part about this injunction is that the law is set to expire in only 3 weeks, which means that it's fairly obvious that the court wants to take things back to the status quo as quickly as possible. So I would like to take some time to go over the details of all of this and talk about how the ruling shows a clear protection of the interest of landlords over the needs of tenants and the social protections from COVID. So let's start off by taking a look at some of the conclusions of the case, which led to the injunction, talk about some of the details of the injunction itself, as well as the dissenting opinion, and the response of New York State to all of this. Now, the case itself is Crucifix versus Marks, in which a group of landlords claimed that the law made it so that they received undue suffering because of their inability to start eviction proceedings due to this form. So let's start off by looking at the conclusions of this case. So when we look at this, this is the last section of this paper that represents all of the case, where it goes over a lot of the details of what basically transpired. And so the irreparable harm that the court determined is going on here is that a lot of landlords were actually suffering financially from this. This is kind of telling because one case here you have Lacasse is now effectively homeless, unable to move into her own house because her tenants refused to move out following the expiration of their lease and have caused substantial damage to the property itself. Now, one of the things that's interesting is most cases, the courts don't tend to take the side of people who have ended up homeless. They're not thinking about the fact that the tenants, in fact, will end up homeless in all of this. And it is only in the case of landlords where people get protected in these ways. And as we will show through the dissenting opinion here, a lot of this is actually kind of exaggerated. And we'll talk about that a little bit. We have also that the applicants, Xianzhao, can no longer pay the rent on their current residence, and yet they cannot move into their own home because their tenants, against whom they obtained a pre-COVID judgment of non-payment and whose lease has expired, refuse to leave. Another applicant, Crucifix, the first name on this, who secured a pre-COVID warrant of eviction against the tenant, is suffering emotionally and has wanted to sell the property for well over a year. And I'm sorry, the emotional suffering of a person shouldn't come at the cost of another person's home, especially during a pandemic. And finally, we have here that the applicant Cohen, who relied on the rent from their tenant to cover their fixed costs in retirement, now fears losing their property altogether. And again, this is kind of exaggerated for a number of reasons. But the reliance here on protecting landlords in a way that most other people wouldn't be protected under the law is quite obvious here, and that the goal of this injunction is thus to protect landlords. Now, when we come into the actual law, CEEFPA, that the law was designed basically to provide emergency relief. The court case here, one of the things that they try to argue is that the state of New York has not sufficiently argued that this is in fact protecting the interest of a people during a public health crisis, considering that the majority of people are now vaccinated. Now, this doesn't take into account whether or not the state of New York has actually reached herd immunity levels. It doesn't take into account the Delta variant or the Lambda variant or any potential future variants. It just says that a lot of the statistics and data that the state of New York has gone into in providing for this case has been outdated because it is from early in the pandemic, which is kind of unrealistic because the information on the Delta and Lambda variant may not be widely available and may not even be available yet, given that this is happening now and you need time to create the studies and data. So a lot of this is really unrealistic in terms of what should be expected and be able to be provided at this current time, especially when a lot of the leeway needs to be provided, in this case to the state, in order to make sure that people are protected because of pandemic conditions. Now, one of the things that happens here at the end of the case is indeed, as the state itself highlighted in the Court of Appeals, there is a new government-funded relief program for tenants who meet the thresholds, which includes an eviction moratorium for participants, but gives property owners an opportunity to challenge assertions of hardship and does not block the case from being filed or proceeding. That will protect tenants who have truly suffered financial or health-related harms due to COVID-19, meaning that there is simply no public interest in CEEFPA's continued enforcement. So what's going on here is that they're making the claim that CEEFPA has in fact been an issue because it does not allow for the landlords to create any sort of position or court cases against these tenants to prove that their means have not been tested, rather that they cannot assert themselves that they have in fact gone through hardship. And the reason for that, according to the actual injunction itself, is that no man can be a judge in his own case, which is consistent with due process clause. So when we go through the dissenting opinion in all of this, we find that a lot of the stuff really isn't on point when we really go over it. What the majority of the justices have determined does not really hold up as far as I'm concerned. Now, the legal rights at issue are not clear according to the dissenting opinion. The fact that they have gone through hardship cannot be viewed as a deprivation because of this particular law, because it's only deferring it for 3 weeks. So that's the first claim of dissent. Given that they will have the right as of August 31st to be able to just, file these claims against their tenants, they're not really losing their rights. It's more being deferred for public safety. Second is that the applicants had also argued that it violated their First Amendment rights. This was actually thrown out in the court case simply because of the fact that they were not compelled to actually speak anything except for the truth and the actual law and to put the details of the law in their documents, which really isn't compelled speech. It is more so something that happens all the time. Whenever you have a legal document, you often put the law in the document. So it was kind of absurd, and even the majority justices in the case kind of dismissed that. But the second thing, and I think this is the most telling part about this, about where the main part of the Supreme Court's coming from, is that the applicants have not shown that critical or extringent circumstances justify our intervention. As I have said, CEEFPA's pause on eviction proceedings will expire in less than 3 weeks, alleviating the hardship to New York landlords. Any hardship is further alleviated by provisions of CEEFPA that provide relief from foreclosure for property owners who own 10 or fewer dwelling units. So basically, the people who are claiming that they are under such duress because of all of this are actually protected by the exact same law that they claim is harming them, which means that if any of them do in fact have 10 or fewer dwelling units, they do have a home to go to. They are not going to lose their property. And even if they can't make their own rent, they are in fact protected, which means that a lot of this is exaggerated. And it's more about the landlords wanting to be able to do with their tenants as they wish and having control of their property, which in this case is harmful to the society and causes a harm. That's not even counting the ways that being a landlord negatively affects society because they're not actually providing a service for people. They're not providing housing. They are, in fact, extracting wealth from people for something that they need to survive. And so that's really what this boils down to. And in the third case, it's really worth noting that the state of New York does have a certain level of protection to determine whether or not something is safe based on medical and scientific uncertainties. That is written into the law. And so that really should have been looked at and justified. And that's kind of what I was getting at when I said that the state of New York technically has the right to respond in this way based on current information, even if studies haven't been fully performed or done. To add to all of this, I just want to show off Senator Kavanaugh of the state of New York, his response to all of this. I continue to believe that CEEFPA was a constitutional exercise of our authority and our responsibility, as Justin Stephen Breyer's dissent phrased it, to respond to a grave and unpredictable public health crisis and guard and protect New Yorkers. With due respect for the decision issued by the court, I will draft an attempt to enact legislation to shore up the moratorium in a manner that's consistent with the constraints of the court. So all this is really doing is forcing them to rewrite the law in a way that goes around this. That basically says that they have to provide some sort of means testing in order for tenants to be able to prove that they are in fact suffering under the pandemic. And honestly, the fact that they have to prove that is kind of absurd. Whereas landlords don't have to prove it, and in fact are just kind of getting the protection as they go. And the fact the courts are just backing them up right away. And I think that's a telling thing, right, about where the court prioritizes. It prioritizes property over the safety of people during a pandemic. It prioritizes property over the needs of tenants to have access to a home. And the fact that the landlords are still going to get the full payment due means that they're not really suffering in all this. They're going to get those back payments. All of that is going to be debt that is going to be put against the tenants, which means they're not really suffering. And it just comes off as really problematic that they are getting all of this handed to them and that the court is protecting them. And again, at the end of the day, that's what the law tends to protect. It tends to protect property over people in almost all cases. So in addition, it's important to note that just because of this injunction, it doesn't even mean that people will actually be evicted or anything will go wrong. There's still the Tenant Safe Harbor Act in the state of New York and the CDC moratorium, which was extended, which I covered last week or so, that will protect New York City in addition to it because it's a federal protection. And so in all of this, it's worth noting that it doesn't actually do anything and that a lot of the rent assistance is still being handed out, which according to the state of New York will be money that will end up in the hand of renters, which will eventually get transferred to the landlords anyway. Further proving that this is not going to harm landlords at all and is in fact only going to help them in the long run. Meaning that the state really is functioning in such a way that landlords are still going to get their money and protections. And so ending this law 3 weeks early really isn't going to do anything, but the Supreme Court just seems to be desperate to get back to the position of the status quo and to reach a point where we end up in a place where we just pretend that the pandemic is over. And as a matter of fact, it's not. As we're seeing more and more, the Delta variant and the Lambda variant are going to be causing more and more problems, even in a place like New York. Some people who are vaccinated are still getting full symptoms, and with the Lambda variant, it seems that there's a potential that it might actually push past the vaccine in certain instances. And again, as it keeps spreading, as it keeps doing all the things that it's doing, it's going to cause more harm. There are still over 13 million Americans who are at risk in the next 2 months of losing their home if we were to just end the moratorium. And this is disturbing. And it's disturbing that the needs of landlords here are being prioritized over the needs of the society as a whole and tenants, as usual. And this is the status quo that the Supreme Court wants to uphold. So with that said, if you like this video, please give it a thumbs up, hit the subscribe button and bell for notifications. You can follow me on Twitter and check out my Discord in the description down below. My name is Anarchist Tara, and I thank you for watching.